Welcome back to the channel. Today I'm talking on the subject of bail. But first of all, if you are just joining our legal community and you've got questions of your own, make sure you like, comment, subscribe and hit the bell icon to make sure you don't miss out on new videos. The first thing to say is that there are two types of bail. There's police bail and there's court bail. Police bail might be where you've been arrested for an offence and perhaps interviewed, but then you are released pending further investigation, but on what we call pre-charge bail. That means you haven't been charged yet, but the police want to conduct further inquiries and they want to make sure that you come back. They may even attach certain conditions to your police pre-charge bail. This means, for example, you may be required to live at a certain address or to not live at a certain address. For example, in some sex offence cases where you are suspected of a sex offence, it may be a condition of your bail that you do not live even at your home address and that you have to live somewhere else. In the case where you have been charged but you've not yet appeared in court, you may still be released on bail but required to attend at court at the earliest opportunity. So as for your rights when you've been arrested, I've done a separate video on this. I will link in the card above and in the description below, so you can go and watch that video after this one. So for the remainder of this video, I'm going to focus on court bail. It's a very broad subject with lots of fine detail, so I'm only going to cover the main elements that you would need to think about. First of all, many defendants come to court only once and have their entire case dealt with there and then. And so in that scenario, bail is not a consideration because it's simply not necessary, because the whole case will have been dealt with at that first and only appearance. Typically, the sorts of offences that are dealt with in one day are very often motoring offences, such as speeding, drink driving, and that sort of thing. So lots of defendants will turn up to court as they've been required to do so. Many will not take a lawyer with them, although I would personally always recommend that you seek representation, because it's just simply better to put your case across if you have professional representation. So many of those offences, road traffic offences, will be dealt with in one day. But otherwise, it is unlikely that the case is going to be dealt with in one day, and most defendants will have what we call a first appearance. So all criminal cases will start their life in the magistrate's court. Many cases will stay and be dealt with in the magistrate's court, but many other cases are sent to the Crown Court, or the defendant might elect Crown Court trial. Again, I've got another video that explains this in more detail. So in the majority of cases, you will have your first appearance in the magistrate's court, and then almost always you'll be sent away on remand, which means you are required to come back to court at a given date and time. And actually, if you fail to return to court on the required date and time, you commit a further offence, which is punishable by up to 6 months in prison. So on remand is the bit that requires you to return to court. However, you may be remanded in custody, which means you're not allowed to go home, but still required to return to court, or you might be remanded in the community, which is in effect what bail is all about. So talking about bail in the community, which is effectively what everyone really wants to know about, because if you are charged and you're required to return to court, you want to know whether or not bail is going to be in the community. In other words, whether you're allowed to go home before you're required to come back to court. The starting point is that there is a presumption for most defendants in favour of bail, and it's down to the prosecution to raise an objection. But if the prosecution don't object to you having bail, then you are likely to be bailed. But if the prosecution do raise an objection, this is where the law on bail really comes into play. If the prosecution object to you having bail, the prosecution have the obligation to raise those objections, and then the defendant can make a bail application to resist those objections. And so there's this argument in court as to whether or not the objections justify the court refusing you bail. There are two scenarios where the presumption of bail will not apply. So remember, the presumption is the starting point that you will get bail unless there's an objection. But the two scenarios where that will not apply is where the defendant is appealing. In other words, there has already been a decision, a conviction, and the defendant is appealing that conviction or sentence. And so the presumption of bail does not apply in that scenario. The defendant may still be given bail. It's just that the starting point in favour of bail does not exist in that particular scenario. The second scenario is when a defendant is convicted in the magistrate's court but is being sent to the Crown Court for sentence. So this is the scenario where a defendant may have had a trial in the magistrate's court and been convicted. So let's say the magistrates accepted jurisdiction to try the case and the defendant didn't have or didn't exercise the right to elect Crown Court trial. The defendant is being convicted in the magistrate's court, but the magistrates have decided that their sentencing powers are simply not enough. In other words, the defendant should get a very long custodial sentence, but the magistrates don't have the power to order that. So the defendant is then sent to the Crown Court, which obviously does have the power, greater sentencing powers than the magistrate's court. So in that scenario as well, this presumption or starting point in favour of bail will not apply. It's not to say that the defendant won't get bail. Perhaps the defendant will. It's just that the presumption doesn't apply in that particular case. So now looking at those objections that the prosecution might raise against the presumption of bail. There's an awful lot of law surrounding bail, and I cannot possibly cover everything. Even if I were to sit talking for an hour, I wouldn't get through absolutely everything that there is, but I'm going to give you the broad overview of what might apply in most cases to most defendants. And the starting point that goes back many years is that there are essentially three main grounds to object to bail. The first of those grounds is that the prosecution may say that if granted bail, the defendant is likely to fail to surrender to custody. In other words, if the defendant is allowed out into the community, then the defendant is unlikely to return to court for trial and sentence. Now, if you think about it, if the defendant is charged with a very serious crime and there's a lot of evidence against him and he's likely to be convicted and likely to go to prison for a very long time, that's quite a strong motive for the defendant to, let's say, not return to custody, even flee the country, and so on. So the first main objection would be that if granted bail, the defendant is likely to fail to surrender to custody. Another scenario where there might be a high risk of a defendant not coming back to court might be if the defendant is homeless and essentially doesn't really care what's going on or doesn't know what's going on, perhaps very often is high on drugs and just generally doesn't know what day of the week it is, let alone when and where to appear back in court. That might be part of the objection by the prosecution to persuade the court not to grant bail in that particular scenario. The second main ground that the prosecution may raise as an objection is that the defendant is likely to commit further offences whilst on bail. Now, this will be for the court to assess the risk as to whether the defendant is likely to commit further offences whilst out on bail. Very often, offences are simply a one-off and the defendant is not likely to commit a further offence and there's no apparent risk that he's going to do so. In some cases, such as drugs offences, it's very common for a defendant to need to go out and steal things and rob people to get money to feed a drug habit. So the prosecution may object that the defendant is very likely to commit further offences whilst on bail to feed this drug habit. And the court, again, will have to assess the risk as to the likelihood of a defendant committing many further offences whilst out on bail for the weeks or months that it will be between being released on bail and appearing back in court for the instant offence. The third main ground is not so common, but it does happen, and that is interfering with witnesses. The prosecution may object that if released on bail, this defendant, perhaps accused of a very serious offence, is likely to go and interfere with or otherwise intimidate a witness, perhaps pressuring them not to come to court to give evidence, perhaps pressuring the complainant in the case and pressuring the complainant not to come back to court to give evidence. But this is usually in some of the most serious cases or perhaps gang-related cases where there is a very real risk that the defendant or part of the defendant's network is likely to interfere with a witness in order that it's going to compromise the case against the defendant. So as I said, this is quite a rare ground, but it certainly does happen in some of the more serious cases. Now, the level of proof required by the prosecution to make out one of these grounds and objections to bail is set to be substantial grounds for believing that the defendant will fail to surrender to custody, commit further offences or to interfere with witnesses. In reality, case law suggests that this is not a significant burden to overcome, so it is not the same level of proof that you would have in any other part of a criminal case. It's certainly not beyond reasonable doubt. The prosecution simply have to show that there is substance in the argument that either the defendant is likely to fail to surrender, commit further offences, or interfere with witnesses. And the court will decide, again, based on the risk and based on the objections and the arguments that are put forward by counsel as to whether or not the grounds and objections are made out. One overarching thing I should say about these grounds is that if it is highly unlikely that the defendant is going to get a custodial sentence, or that a custodial sentence is simply not an option for the offence in particular, then these grounds will not be available, because it makes sense that if the defendant is not likely to get a custodial sentence anyway, then there isn't generally a need to be remanded into custody pending the trial, because even if convicted, the defendant isn't likely to be sent to prison. There are then three other fairly technical situations where the court need not grant bail. First of all, if the defendant is already a serving prisoner, so in other words, they're already in prison for one offence and then evidence has come to light and they are charged with another offence and likely to be sentenced for another offence, but they're already in prison, so there's no need, obviously, to grant bail in that situation. Secondly, in some fairly serious cases, such as paedophile cases, the court need not grant bail if it's for the defendant's own protection. In other words, if there's a very serious offence and there's a very real likelihood that the defendant is going to come to harm if released back into the community, the defendant may even opt to remain in custody for own protection reasons. So in that situation, the court need not grant bail if it's for the defendant's own protection. Finally, if there's simply not enough information for the court to make a proper decision regarding bail, then it need not be granted at that time. And it may be that the decision is simply made 48 hours later when proper information is available and proper arguments can be heard, either for objections or an application to resist those objections to bail. And one other situation that may seem fairly obvious is that if the offence in question was committed whilst the defendant was already on bail, then the court fairly obviously need not grant bail in that scenario, because if the defendant was already on bail, it's essentially the court trusting that the defendant's not going to go out and commit further offences and so on. But if the defendant does in fact go on to commit a further offence and then is brought back to court on a second offence or even third offence or fourth offence, then the court need not grant bail in that situation either. Now, as usual, it's not quite as simple as that, but that's the general framework of bail as to what objections are raised, why they are raised, and how the court makes those decisions. But then there's been lots of developments with case law and decisions on lots of different sets of facts where the court has had to make a decision. And so rules, effectively precedent, has been created around this framework to decide on those cases. For example, as I hinted at earlier, if a defendant is likely to be remanded into custody for several weeks or even months, and yet their offence is relatively minor and not likely to get a custodial sentence, or if they do get a custodial sentence, it's not going to be perhaps even as long as the duration that they are remanded into custody for, that obviously doesn't seem particularly fair. So this is obviously a very broad, very technical and very complex area of law as to how the changes in the law affect these main grounds that I've described for objecting to bail. And essentially it applies slightly differently depending on the type of offence. So we have indictable offences. That means an offence that is serious enough that it can be heard in the Crown Court on an indictment. So if it is an indictable offence, and that includes either way offences that you may have heard of, if it is either way, it means it could be heard in the Magistrates' Court or it could be heard in the Crown Court. That makes it an indictable offence. So those are indictable offences. So almost all violence offences, except for common assault, which is still summary only, almost all theft offences and dishonesty offences are indictable. Almost all sex offences are indictable, just to give you an idea. So most of the offences that you will be familiar with will likely be indictable offences, save for those few that are summary only. Some of the examples that will be summary only will be traffic offences, which will only be heard in the magistrate's court. Now, those summary-only offences can be broken down further into those that are summary only and you can't go to prison, or summary only, but there is a possibility of going to prison. Now, these big grounds that I've described, the law says that they will not apply in the first instance for summary only offences when you first turn up. The idea being that they are likely to be very minor offences, and it's highly unlikely that anyone is going to fail to surrender to custody, to commit further offences, or to interfere with witnesses for something so minor. The idea being that it is so minor, why would somebody make the situation far worse for themselves when they're only being charged with something very minor? However, if they are released on bail for a summary-only offence and there's some conditions attached to it, and then those conditions are broken or they fail to surrender and something like that, then those grounds will become available even though they are summary-only offences. And for all indictable offences, these big grounds that I've described are automatically available for the prosecution to raise as objections to bail. Looking at some of the much more serious offences such as murder and rape, there are quite obviously special provisions for those. If you are charged with any one of these offences on a list, and you have a previous conviction for any one of those on the list, then there must be exceptional circumstances to justify the court granting you bail for any one of those offences. Also, special provisions for murder. First of all, only a Crown Court judge can grant bail for murder. A magistrate simply cannot do that. It must be passed to a Crown Court judge. And murder, even if there are no previous convictions, will only be granted if there is no likelihood of the defendant causing harm or mental injury to any other person. So generally, when the court looks at all of these grounds, the court is going to look at a number of factors to make a decision as to whether or not to grant bail. First of all, quite obviously, the type of offence and how serious it was, perhaps some of the details of the offence that might make it stand out in a particular way. This might include, for example, some of the evidence, if there's particularly strong evidence in the case, and therefore a conviction is very likely in the court's view, even though obviously no conviction has happened yet, but the court might look at the strength of the evidence and the likely custodial sentence that may follow, and all of these will be factors that the court will consider when making a decision. The court will also look at the character of the defendant in question, whether there's a history of criminal activity or whether it's a first and perhaps one-off offence. All of these things will be arguments heard by the court in persuading it either to grant bail or to refuse bail. So if a court does decide to grant bail, broadly speaking, there's no limit on the conditions that a court can impose. Quite often the court simply wants to impose some level of control, such as where the defendant is living. So it might be a residence condition that the defendant must reside at a certain place. There may be a curfew. There may be restrictions on where the defendant can go or with whom the defendant can associate or spend time with, or any other conditions that the court thinks are suitable or necessary in order to allow the defendant back into the community whilst awaiting trial. In most cases, the first application for bail is made at the first appearance. Obviously, most defendants want to be released back into the community whilst waiting trial. If that application is refused and the court remands the defendant into custody, then the defendant can make another application when the case returns to court, which would be within 8 days, so normally a week later, a second application can be made. If both of those applications fail and the defendant is once again remanded into custody, there can be an appeal to the Crown Court to have a judge consider whether or not bail should be granted. But after that, if the Crown Court judge refuses bail and the defendant is remanded into custody, that is normally it. So there are 3 opportunities, unless and until there's a change in circumstances where the defendant might be able to make a new application based on a change in circumstances. It is possible to appeal the very first application refused by the magistrate's court straight to the Crown Court to have a Crown Court judge decide, but if that's the case, then you lose effectively the second opportunity at the magistrate's court, so that once you've been to the Crown Court and if the Crown Court refuses bail, then that is it. I should add finally that the prosecution can also appeal a bail decision. Although it's rarely done, it must be indicated orally at court and confirmed within 2 hours in writing. So that's just a broad overview of how bail works. There are many more intricacies that I may look at individually in discrete videos, so make sure you subscribe. Let me know in the comments which aspect you are confused on, you want more details about. Make sure you come back. Thanks for watching, and I'll see you next time.